for coming. So for those of you who don't know me very well, my name is Eva Lekbal. I'm a lecturer at the law school, and I'm also co-director of the Essex Transitional Justice Network. And I'm very happy to see you here today. This is an event co-hosted with the Essex Human Rights Center and the Department of Government. So I really want to thank Carla, who's the director of the Human Rights Center, and also our colleagues from government for co-hosting this event. Those of you who do know me know that the former Yugoslavia, and particularly Srebrenica, is something I care a lot about. Some of you did come to the film screening yesterday. And so I'm very, very happy that we were able to put together this event. Because, yeah, so this year marks the 30th anniversary of the Srebrenica genocide, which was the first genocide on European soil since the Holocaust. And so between 11th of July and the 22nd, around the 22nd of July, 1985, over 8,000 Bosnian Muslim men and boys were killed in the areas around the town of Srebrenica, which is a town in eastern Bosnia, by Bosnian Serb forces, by the Bosnian Muslim army. And this also happened in the presence of Dutch UN peacekeepers. And just also want to point out that this genocide happened in the wider context of the war in the former Yugoslavia, which led to the breakup of Yugoslavia and created the state that we have today. So trying to get this right now, but Slovenia, Croatia, Serbia, Bosnia, Montenegro, Macedonia, and Kosovo. And the wars happened between 1991 and 1995. So this happened right at the end in the summer. And we had the peace agreement, the Dayton peace agreement in December of 1995. Just to also say that, you know, the wars in the former Yugoslavia, there wasn't just Srebrenica, obviously, there was lots of mass atrocities. We had widespread, you know, massacres and sexual violence and torture and all sorts of atrocities, forced displacement, ethnic cleansing, etc. I would, however, say that I think the most serious violence and most of the violence happened on the territory of Bosnia due to the, I guess, ethnic mix of the composition of Bosnia and the tensions there. So anyway, that's just a little bit of context. I'm sure, you know, you'll learn a lot from the panelists. So I'm just going to introduce the panelists, I think, in order of speaking. They will each have about 15 minutes to speak. I'll try to keep time. And then we'll have, you know, discussion, questions, comments afterwards. You know, don't be afraid to comment or ask questions. And also to the panelists, if you feel like you have more you want to say, you can always, you know, give your extra points maybe during the Q&A. So we're going to be starting with Dr. Pravin Katka, who is the lecturer at the Department of Government. Pravin is a former peacekeeper, not in Bosnia, but in the Democratic Republic of Congo. So he will be talking about the challenges, his experience as a peacekeeper and challenges to peacekeeping mandates. We'll then go with Professor Carla Firstman, who many of you know, who is president at the law school and director of the Human Rights Center, and she will be talking about accountability for the failure to protect, navigating between the responsibility of international organizations and truth contributing countries. And then we'll have Professor Ismeni Gizelis, who is also the Department of Government, and we'll be speaking on the evolution of peacekeeping missions and evaluation of effectiveness. So talking about, you know, how mandates have evolved since then. And then lastly, but not least, we'll have Dr. Matthew Gillett, you all know, senior lecturer here at Essex Law School, and he is the chair rapporteur of the UN Working Group on Arbitrary Detention, and also for this event, very important, a former prosecutor at the ICTY, and who was involved in the prosecution of cases relating to Srebrenica. So anyway, so I hope you'll enjoy. And yeah, so there we go. Pravin, if you want to.
Thank you very much. Good afternoon, all. I'm Pravin Katka. I'm Nepalese. I'm a lecturer at the Department of Government. I'm honored to be here, and you know, I'm sat next to distinguished scholars, experts. But it's a great honor to be seated next to Ismeni, who is one of the you know, very big names in peacekeeping, which I'm going to focus. So I've decided to I guess you know, have my talk in three different parts, you know, all interrelated. If you've got any questions, well, you know, I go through my points, feel free to interrupt me. If not, you can can always do the question and answer thing right at the end. Right. So just to start with, the reason I decided to speak about peacekeeping, mostly, things related to peacekeeping in the massacre, is because there's a lot of finger pointing towards, peacekeepers. There has been, related to this, very tragic incident, but also in other, ongoing and past peacekeeping missions. So I'll mostly focus, around that. I think to begin with, the role of peacekeepers in Srebrenica, I'm sorry about my pronunciation, I always struggle with this word, is because there's a lot of, pushback. There was a lot of pushback because, it was a UN designated safe area, right? To begin with, we must all accept that. But then we must also take into account that, there was a lot of like unclear mandates. There was like limited resources, and don't forget this lack of political will also, which I'll touch upon. So from this background, I'd like to now focus on three key discussion points that I've prepared. The first is, I guess, the implications, the ethical implications of Srebrenica, right? Srebrenica. The first, I guess, is on the one hand, we must, there must be acknowledgements, there must be apologies, which I think has already happened, recognizing the failure of the UN peacekeeping mission, the failure of peacekeepers to protect civilians, but also apologies from the UN and also from the nation right here in Holland. But then on the other hand, an interrelated component is, why did this happen? Like there's, critical questions that arise, like why did this happen and what can be done? Right. So first, why did this happen? Yeah. And I'd like to take you to, two other missions while, this, this happened in, 1995, July, but don't forget, like, there were already two similar cases before 1995. The first being Rwanda in 1994, where 800,000 people were, brutally killed, right? I mean, it was pretty gruesome. Hopefully something like that never happens. But then in 1992, Somalia, right? Where basically it wasn't an ethnically, meaning it wasn't between two groups, but then the peacekeepers basically like failed to protect civilians, and ultimately when the US forces came in, there were, in fact, there's allegations that almost 400 to 500 civilians, right? So we must take into consideration, take into account that against these backdrop that 1992, 1994, but then we also witness Srebrenica. So why did these failures happen, like collective? Right? So again, I'd like to now start with inadequate mandates, right? In UN peacekeeping, everything is dictated by mandates. Right? What that means is just as a for a layman, if I were to give you an essay and ask you to do three things, but then I cannot expect from you like a fourth thing. So back then, the idea of POC, protection of civilians, really came into effect only in 1999, right? So as much as we accept and we've acknowledged what could have been done, but in that's all I guess looking at it now. But in reality, the primary mandate of the Dutch peacekeepers was their own protection. Unless and until there's direct harm, in fact, like physical harm, they were not mandated to fire back, right? And don't forget this, the UN peacekeeping mission originally asked for 37,000 troops, right? But only approximately 6,000 were provided. And it was that in this particular area, we only had 300 Dutch peacekeepers, right? And when Mladic came down the hills, he had thousands of men, not just armed, but ready to I guess completely annihilate Dutch, had the Dutch fight back. So let's take into that account. Like the first, which is like mandate, but also lack of proper resources. But then this is also interrelated to this political hesitation, right? don't forget, like we have the NATO, but then, if you read really like into, how this unfolded, which is actually captured in detail, it's quite tragic that the commander was, asked to fill up a form again because the form wasn't the right form. So imagine he's asking for air power, NATO air power, but, there's this, huge delay because he's, filled the wrong form. So I guess my point being here is there wasn't this, I guess this desire, and there was a lot of like this, hesitation from the UN Security Council also. And in fact, the UN also is to be blamed because there were a lot of like false reports. A day prior, when the shelling had actually started happening, the UN really didn't report it as shelling from, the Mladic troops, but something else. Okay. So the first thing that I wanted to, highlight here is why did this happen? Okay. But then the second thing which I want to touch upon now is the impact of not just Srebrenica, but then, of Rwanda, of Somalia, all these three failures combined. And it's very interesting in the sense, you have the Dutch in Srebrenica, you have the Americans in Somalia, you have the Canadians, right? And I'd like to, link this to current peacekeeping, what we call as sometimes like failures or shortcomings, where mostly it's, South Asians and North Africans, to some extent Latin Americans also. Just to make the point that, peacekeeping is an extremely difficult task, right? If these armies could handle it correctly, like there's no point. I mean, it's unfair to expect, more out of peacekeepers out of, who are from developing countries. So the impact, there were three distinct impacts, and I'm sure Ismini will add more, but this is what I'd like to just narrow it down. The first is the Brahimi report, and for those of you who are studying maybe like peacekeeping from a human rights point of view, I think is very important. So what happened was in 2000, in the year 2000, this report came out, which called for clearer mandates, right? First, better resources and faster deployment. So that came out. But then what's also really interesting is what was emphasized now, and we read about it, we talk about it a lot, we scholars, practitioners also, the R2P mandate, right? Responsibility to protect. So it's actually, I guess, I would say it's a function of all these failures in these three missions. Okay. So R2P. But then only after 1999 did we begin to see clear mention of protection of civilians in all US peacekeeping mandates. Right. So in fact, this year is the 25th anniversary of the POC mandate, right? So which only started in 1999. So before that, if you dig mandates, and I actually checked mandates before 1999, you will not see protection of civilians being mentioned in any of the UN peacekeeping, right? So going back to Srebrenica, yes, it's one thing that the peacekeeper should have reacted, right? If you look at the interviews, the videos, I did check last week, and I'm aware this British commander was extremely critical. He said you should have open fire and all that. But if it's really not clearly mentioned in the mandate, I don't think it's fair to expect the peacekeepers firing back at whoever. Okay. So these three things: Brahimi report, responsibility to protect, and the POC mandate. And the POC mandate started with 16 missions, right? And if you dig into mandates now, it's explicitly mentioned the protection of civilians is in fact the primary mandate of all peacekeeping missions. Whether peacekeeping missions are still traditional missions, like for example UNIFIL, which is their primary mandate is to ensure that Hezbollah doesn't come up to the blue line. Lebanon, South Lebanon, cross Litani, come to the blue line and fire rockets against Israel. Right? That's their mandate. But they also, an interrelated primary mandate is also protection of civilians, even in traditional peace missions. Forget if it's South Sudan, DR, Congo, Mali. That's like the core mandate, protection of civilians. So it's very interesting and important that we see how this evolved and what we see today, right? From those failures, from those tragic missions, tragic incidents. How many? Okay, so I'll wrap it. So I want to keep on going. I know I'm not a good speaker like probably the other speakers, but I'm really enjoying it. So thank you.
Don't worry.
So the final thing that I'd like to touch upon is what have we learned? Have these lessons, carried on so that the missions today are more, I guess, effective. Right? And I have to bring two examples. The first is South Sudan, 2013 December, when there was this massive shock, and then there was this ethnic conflict in South Sudan. We had around 6,000 peacekeepers in South Sudan. After the violence, maybe 14, 15, if you look at the mandate, it has gone up to 15, right? But then after this shock, can you imagine, like, almost 500,000 people were killed, actually, 400,000. Right? There was almost like 5 million people displaced, 2 million outside, like all went to Uganda, some went to Ethiopia, some went to Congo, and almost like 3 million internally displaced. So can we, the point that I'm trying to make here is, can we point fingers at peacekeepers when, again, they're really ill-equipped, right? And number two, the mandates are still unclear, and I'll touch upon that. Despite saying protection to civilians, there's still like very, unclear, I guess, specific duties that peacekeepers are allowed to perform, right? So that's South Sudan. So can we, continue blaming peacekeepers? My question, right? The second is what's recently happened after January in DR Congo, and two of my colleagues here rightly left have both been Congo. It's very unfortunate, right? And since January, we've already seen 7,000 people killed in Eastern DR Congo alone by, as a cause of the M23 march towards Goma, Bukavu, take over Eastern Congo, right? But then there were 12 peacekeeper deaths also, 9 South Africans, 3 Malawians, and 1 Uruguayan, right? So there's a paradox here. The point that I'm trying to make here is, the point being is the paradox in peacekeeping, right? On the one hand, you're required to protect civilians with, you're under-resourced, ill-equipped, right? And if you do protect, then you lose lives, right? But yet, the principles of peacekeeping, even till date, you have the mandates, all that, but everything starts with the 3 core principles, which is consent of the parties. You have to have consent. If you don't, you're kicked out. Look at Mali, right? Consent of the parties, impartiality, right? You're still considered, it's not, being neutral is very different from impartial, right? Being neutral means like not reacting, but you react. But the idea is like be impartial. That's still a challenge. And finally, non-use of force is still encouraged, even till date, right? So I'd like to sum up by saying whatever happened in Srebrenica, of course, unfortunate, very, hopefully nothing like that ever happens, but then that happened against the backdrop of 2 peacekeeping missions, which ultimately led to peacekeepers being more proactive, coming up with the reports, this POC mandate. Yet we still continue witnessing failures, so-called failures of peacekeeping. But I just want to wrap up and conclude by saying, is that really fair on peacekeepers, right? Because at the end, peacekeepers are, I think, solely peacekeepers. They're not like counterinsurgency, troops that are mandated to do something completely different, such as in Iraq, in Afghanistan, to some extent, the African Union force in Somalia, which is very different from traditional UN forces. So, thank you very much. I really enjoyed it.
Thank
I
you.
look forward to your questions.
Well done. Carla. Do you want me to run your slides?
Yeah, why don't you do that? Because I have some slides, but they're mainly pictures.
Oh, wonderful.
So there's no text on them. So you can probably figure out where to go about what's this time. But maybe I think it's interesting for me to come right after Pavin. Because firstly, whatever happens in Srebrenica.
Sorry, just to say, these are yours, right?
Yes.
Yeah.
Srebrenica was a genocide. Peacekeepers are there, but they're not on holiday. They have a particular mandate. And whilst the individual peacekeepers have to follow the mandate, you got the chain of command. The chain of command has an obligation to ensure that the mandate is appropriate. So I'm going to be looking at it from that more critical perspective in terms of how to ensure that whatever happened in Srebrenica, which actually was a genocide, is not capable of being explained away by, mandates, because that, in a way, is the problem. So I'm going to be looking at different aspects of accountability. The first one that I want to look at is obviously the Bosnian Serbs were responsible for killing 8,000 Bosnian Muslim men. But the first additional area of responsibility that you have is the involvement of the JNA army, which ultimately is the Serbian army following the split of the former Yugoslavia. So when looking at the involvement of Serbia, this case came up before the ICJ, and essentially there wasn't enough to show that that the Yugoslav army was responsible or was involved in the commission of acts of genocide, nor did the ICJ determine that there was enough evidence to show that they were complicit in acts of genocide. That, I would say, was a little bit more controversial in terms of whether or not there was sufficient information about complicity. But what the ICJ finally concludes is that Serbia was responsible it failed in its obligation to prevent, so that it didn't use the clear powers and abilities that it had to ensure that genocide didn't take place. It's an obligation of means, not of results, but nevertheless, it didn't do enough. What's interesting about the International Court of Justice decision is that on the issue of reparations, the court determined that the finding of failure to prevent was sufficient as reparations. So making the acknowledging of this was sufficient, that the court didn't actually need to consider whether material or moral reparations were appropriate in this case. So obviously, this was very concerning for the Bosnian Muslim population. But what I really want to focus on is the issue of the institutional accountability, so the issues of international organizations' responsibility and the responsibility of Dutch VAT. I think it's really interesting to look at this in more detail because the aspects of accountability are still, I would say, very challenging to unpack. So the first factor to consider here is who has responsibility. Is it UNPROFOR, which is the UN mission, or is it Dutch VAT, or is it some element of both? The law says, in principle, that this is a matter of who has effective control. But sitting next to a peacekeeper, who has effective control on the ground? It's hard to say. The UN obviously has effective and overall control because it's a UN peacekeeping operation, and that's absolutely clear. But from a practical point of view, in terms of chain of commands, the Dutch were significantly had significant engagement. But when it comes to how the legal cases have determined this issue, the Dutch case, because these cases came up before courts in the Netherlands. You had the Mothers of Srebrenica, who became an advocacy group to advocate for accountability in all kinds of forums. And essentially they brought their claim to the Dutch court saying, excuse me, 8,000 people died, you were there to protect us in a safe haven, where were you? And the Dutch courts essentially said that the UN has responsibility, though for very specific incidents, there was some recognition that the Dutch bore a percentage of the responsibility. So that is in itself, I think, quite interesting. The second question, did the UN or Dutch VAT breach due diligence obligations? I think is a question which hasn't been fully considered. So the UN has a mandate to maintain international peace and security, but in this case, arguably, UNPROFOR's ability to act is predicated on a need for the authority from the political organization, organ of the organization, so the Security Council. If it didn't have the Security Council permission, as Pravin rightly said, there was little ability for it to act. But like states, international organizations have obligations to take positive action, not only negative, but in peacekeeping operations with the protection mandates, there will be instances when the policies, decisions, and actions of international organizations will significantly impact on individuals' lives and well-being. On one end of the spectrum, the decisions of the Security Council to upgrade or not a particular mission, to reinforce troop contingents, or to expand the types of activities that troops can engage in may all have significant impacts, as we've seen. So the articles on the responsibility of international organization, the commentaries note that the obligation is both content and fact specific. So the contingent on the organization being in a position to prevent, which arguably would not always be the case, even if in the same scenario, they're not able to, they're very able to meet their negative obligations. So in this case, such batch would, or the UNPROFOR would have been very easy to refrain from committing force, but would it have the same ability to prevent others from doing that? To what extent is an international organization responsible when it fails to obtain the authority from its member states? And that's really the key question here, but it's not really clear cut. There are certainly questions about whether the executive, so whether the Department of Peacekeeping Operations or others did all within its power to advise the decision-making body, in this case the Security Council, of the significant risks to the civilian population. Arguably, the duty and authority to act can be even greater when the organization operates safe havens. Or otherwise has clear charge of vulnerable people in need of protection, or whether where it already has an enforcement mandate but fails to apply it effectively, which was not the case here. Didn't already have an enforcement mandate, but it was clearly operating safe zones. And for the individuals, if you think about the Bosnian Muslims who are coming to the safe zones to be protected, from their perspective, the failure to receive that protection was obviously significant. But what's interesting, I find, is that the issue hasn't really been decided by the courts. So the Dutch Supreme Court basically says that it would be inappropriate to scrutinize Security Council decisions, but it does so in the context of considering whether the UN is immune. It doesn't do it in the context of considering the adequacy of the UN's actions in relation to its duty to protect. So the question of the UN's duty to protect is still somewhat fuzzy from the perspective of the case law. And in my view, that is a significant weakness of where we are. Another issue to consider is how do we resolve these differences of opinion legally? So often diplomacy is not enough. We know from that the UN Security Secretary General apologized for the unfortunate incidents of Srebrenica. There was also an apology in respect of Rwanda, but at the end of the day, is an apology enough? It's a bit limited when there's been no effort to learn. It kind of makes a farce of peacekeeping if there's nothing done for the victims and no institutional accountability. So formally, the UN is immune from proceedings in domestic courts. So the ability to challenge the UN's version of how it sees its role and mandate is not really capable of being challenged. There's some exceptions, but those exceptions are really narrow. The rationale for immunity is really important. It gives the organizations independence. If they risk being sued all around the world, they wouldn't be able to do their mandate. And that's absolutely clear. both the Dutch Supreme Court decision in Mother of Srebrenica and the European Court's consideration of it after the fact, they make much of the fact that entertaining claims against the UN would require Dutch courts to scrutinize the way in which the UN discharged its core functions of protecting international peace and security, which would interfere with the full fulfillment of key mission of the United Nations. So this is the main argument here and where things end. But the problem is it shouldn't really end there. There's a convention on the privileges and immunities of the United Nations. And that convention has a clause, which is clause 29, Article 29. And that clause says that essentially that when there's an assertion of immunity, which prevents a matter from being adjudicated in a court, the UN has an obligation to set up an alternative forum to deal with that gap. But if you read the wording of Article 29, it's framed rather narrowly because why? The Convention on Privileges and Immunities of the UN was drafted right after the UN was founded. So it was very limited and one couldn't necessarily foresee the kinds of situations we have now. So basically the UN says that because the disputes of this kind of nature, so Srebrenica, should the Security Council have acted, are not private disputes involving, I don't know, motor vehicle accidents or rental agreements or small matters. There's no obligation for the UN to set up a separate mechanisms to resolve them. I'm going to quote from what the UN has formally said in relation to claims which were brought about in Haiti. So not in relation to Srebrenica, but this is basically the position of the UN in relation to its privileges and immunities. The organization does not agree to engage in litigation or arbitration with the numerous third parties, these being the victims of severe violations of human rights and humanitarian law, that submit claims, often seeking substantial monetary compensation based on political or policy-related grievances against the United Nations, usually related to actions or decisions taken by the Security Council or the General Assembly. Such claims in many instances consist of rambling statements denouncing the policies of the organization and alleging that specific actions of the General Assembly or the Security Council have caused the claimant to sustain financial losses. The Secretary General considers that it would be inappropriate to utilize public funds to submit to any form of litigation with the claimants to address such issues. So basically, the UN is saying piss off to the victims, but because of immunities, there's no other avenue for these claims to be decided. So when this came up in relation to Haiti, the UN Special Rapporteur on Extreme Poverty, because it related to that, called this statement morally unconscionable, legally indefensible, and politically self-defeating. So the UN simply decides not to submit itself to any form of internal claims process, but given the absence of an alternative forum, the de facto restriction is an additional, virtually absolute barrier to the resolution of the complaints. So the counter argument, of course, is that the Convention on the Privileges of Immunities deals with a number of limited scenarios, but there's no obligation for it to be restricted to those limited scenarios. It can certainly create alternative dispute mechanisms where it sees the need to do so. That it hasn't done so here, it's taking advantage of a weak legal framework and deciding not to fix it. The problem is that states are very keen to retain this gap in accountability for financial reasons and also other additional reasons. So you have a gap because the people who are calling for that gap to be closed are the most vulnerable people. They're victims of human rights and humanitarian law violations that have no access to change the status quo system. Final point to mention, which is a bit separate from this, but it's the absolute final point. Do victims have a right to see perpetrators prosecuted? It's a separate point because, of course, there were criminal investigations in relation to Dutch acts senior leaders in Dutch BAT for a variety of their actions linked to Srebrenica specific incidents. And basically, the Dutch courts or the Dutch prosecution services decide they carry out a full investigation, but they decide not to prosecute in the end. This is despite the fact that it's absolutely clear that the three individuals against whom there were investigations were implicated in the deaths of a number of Bosnian Muslim men. So the European Court of Human Rights affirms that there's no lingering uncertainty as regards the nature and degree of involvement of these three individuals. But despite this, the European Court of Human Rights this didn't imply necessarily that the victims had an independent right to see these individuals prosecuted. So there's an obligation to carry out an investigation under Article 2 of the European Convention of Human Rights. There's not an obligation for that investigation to turn into a prosecution. So that's where things matter. So in terms of what we can conclude, you have a constellation of factors which contribute to the absence of any kind of accountability for victims of these kinds of horrific abuses. The first is the way attribution of conduct is dealt with, because typically the UN will be determined as the one who should bear liability, but then there's no venue for that liability to be ascertained. And the victims have no ability to challenge that because of the political way that the UN sets itself in motion. Sorry if I went over time. Thank you.
Thank you so much, Carla.
Now we have Ismena. You want to go ahead?
Hi. So I come from a political science perspective, and that's very different from law, right? So as a political scientist, the questions I usually ask is who gets what, when, and how. So it's about distribution of outcomes, distribution of power. A lot of my work has also been influenced by the fact that the country where I'm coming from had experienced a civil war, one of the worst in the 20th century, per capita, probably worse than Bosnia. But there was no UN, okay? No intervention. Just to paraphrase an article, the war had a chance. And the outcome reverberates down into generations. So that raises for me two fundamental questions. If not an intervention by a third party, could be UN, could be something else. What's the alternative? Because that's how we compare things in political science. And when it comes to the UN, is it effective? And is it effective in peace or in war or both? And this is a fundamental question, actually, because in the literature is not, there are some studies that suggest that UN can perform well when it comes to war and protecting civilians or containing the spread of violence under certain conditions, which are very restrictive, but it might be better in dealing with the aftermath of the conflict. Now, as Praveen mentioned, there was a whole context at the time that there were a lot of failures, not just Srebrenica. It was accumulation of cases with horrendous implications. And at that time, the missions were quite small with very specific characteristics and fit probably for the type of conflicts they were encountering. So in the international system at the time, before that, we had predominantly conflicts between states and very few civil wars or domestic conflicts. And the UN was created to deal with these international types of conflicts. The only time that dealt with a domestic case was in the 60s, which was a disaster, and therefore they abandoned altogether and come back again now in the 90s, 30 plus years later, to actually engage with domestic conflict. Without having either the mandates or the characteristics, as Praveen mentioned, is 300, you said, Dutch peacekeepers, 300 in Rwanda as well, extremely small forces. The moment that we have the Brahimi report and changes in the mandates that allow different size of missions, this also changes the effectiveness of the UN is a different context. So let's compare that to Sierra Leone and Liberia. Horrible conflicts. Small countries, both had missions roughly around 16,000, 17,000 troops versus 300. Now, in the case of Sierra Leone, it's interesting because it started as another UN disaster mission. And then there was a change in the mandate that allowed different size of a mission, different leadership. India took over. And then you had also the paras entering and basically stabilizing the situation. So you had a different level of commitment that brought the end to the conflict. And Sierra Leone, one can reasonably argue, is that this is not obviously a wealthy country, but it's a country that has remained peaceful for 20 odd years. That's a long time. Something similar happened in Liberia, and that's a country actually I know relatively well. And it was actually one of the cases where the government requested that the UN would stay put for several times. So it was supposed to withdraw, and then the government, please stay a little bit longer, and then finally they withdrew in 2018. So the change in size has been quite crucial, and that's what a lot of studies show, that the size of the UN missions make a difference, especially at local levels. One of the challenges for the UN is fragmentation, and Bosnia to some extent had that. It's very difficult for the missions to handle highly fragmented conflicts. And one thing we observe now is actually, again, highly fragmented conflicts like Syria or Libya, and part of that has to do with the international system. So the Security Council, whether we like it or not, determines a lot of these decisions, or all. Since 2014, we don't have a new mission because basically after Libya, the China and Russia basically check out. So what we have are the remains of whatever missions were before 2014, and that fuels a lot of the fragmentation and basically renders the missions actually quite ineffective. On the other side, we also find, and that's quite consistent, that in their presence, when they are deployed and quite like spread out in a country, we find evidence of improvements in education, improvements in hospital visits, vaccinations. So a lot of developmental indicators improve in the presence of peacekeepers. And that's something that we don't talk a lot about it, but it's actually quite strong evidence for that. Especially and when you look at quite localized areas. So that converges that probably they are more effective in dealing with peace once they have, rather than actual fighting. And it's also important to keep in mind that UN missions usually go in when there is a peace agreement. They have to keep the peace. So peace agreement means that the parties have already agreed on some basic rules, and then the presence of the peacekeepers is to actually contain them or prevent them from trying to change the terms of this agreement. If you don't have an agreement, the chances of having a peacekeeping mission being effective are very low. One other thing I want to mention that has changed a little bit, a lot of these missions following the early 90s is 1325, Security Council Resolution 1325. Because it changed a lot of the mandates and approach, not just in terms of protection of civilians, but also specifically for women. And again, there we have some evidence that you might argue that it's mixed evidence, but sometimes there are parameters when there have been successes and other cases where being less successful. And interestingly enough, one area where there is still consensus in the Security Council is sexual violence. And right now, it's the one characteristic of a conflict where the Security Council still responds unanimously. And the most recent was against M23 in January 2025. So I just don't want to go too far, too long, but just to sum up, the fundamental question from my perspective is it effective, under what conditions, and is it effective to deal with the actual conflict, or is it effective to make sure that after some agreement has been reached, that things do not recur, and therefore allows the space for the communities or the regions or countries to slowly recover. And probably in terms of the latter, I think there's some evidence that it can do something. The question is it the UN, or it could be anyone? It could be the African Union or the European Union. And that's a difficult question to answer because we don't have a lot of studies that actually compare these organizations. One may argue that the UN might have an advantage because it's more universal. Although the composition in terms of who are the peacekeepers also makes a difference. So there are studies that show that if you have peacekeepers who share some cultural affinity with the local populations, also tend to perform better. But these are all areas that are not, we don't have a lot of research on. The last thing I want to say is a story I heard by a former peacekeeper. He's a friend of mine. He was in the British Army, a medic, and he was deployed initially as part of the UN, wearing the blue beret. And he still has nightmares from the things he witnessed. And he said the worst thing for him was that they were not allowed to intervene. They had to remain neutral. And then he juxtaposed that to the NATO mission, when they actually could go as British soldiers, and the reaction was completely different because of what they were representing and what they could do. And I think that's an interesting story, especially the feeling of powerlessness that he had, even though there was the same army, same skills, if you want, but in one case, they were as UN, the other one as British soldiers. And I'll stop here.
Thank you very much. Do you want to run your own
Yeah,
slides?
so maybe if we switch places here.
I think if we share on here, or here.
Where should we move?
Yeah.
You sure?
Yeah.
It's more for us than them, actually.
Okay, thank you very much. I can
Okay,
That's fine. let you rest. So to backfill some of the substantive details about what happened in Srebrenica, some of my slides don't take a life of their own. I'm going to start with this image, which is Ramo Osmanovic. He's actually a Bosnian Muslim, one of the victims, and it's a very tragic image because he was forced by the Bosnian Serb perpetrators, who you see here in some of their camouflage gear. This will be on the probably Sandici meadow fields just beside the forests where thousands of Bosnian Muslim males were hiding, to call out to his son, Nurman, and actually summon him and say, come down out of the forest. It's safe here, as you see, with the Serbs. And his son did, and many other thousands of Bosnian Muslims did as well. And as we know and we've heard, they were then in a very systematic and organized way executed en masse. And the reason I highlight that is to say that you're dealing in these situations with quite cynical perpetrators who will instrumentalize others who are there, the direct victims, but they will, and they did also instrumentalize Dutchbat to carry out some of the activities. And at least one Dutchbat member carried out a similar type of activity, was found to have also summoned Bosnian Muslims who were afterwards executed. So it's a very complex situation, and it's always extremely important not to lose sight of the key, most responsible parties and most responsible individuals within those parties, which in this case was the Bosnian Serb military and the commanders in particular. I also want to highlight some of the challenges that even based on quite a large scale crime with a huge number of victims came up during subsequent trials, which were by no means straightforward. And I think from that we can draw lessons about reaching conclusions on genocide and actually entering convictions on genocide. It's a term that's often stated in many circumstances, but when it comes to the courtroom and having to actually prove it, it's quite different. People don't write down let's commit genocide against such and such a group. Usually, you have to infer it from a lot of circumstances. And when people get in front of a group of judges and they're sworn in and have to tell the truth, what comes out is not going to be the same as what they might tell a journalist, what they might tell you as a human rights officer in a confident private space, or what they might tell their friends. So it can be very different. In terms of Srebrenica itself, just to orient, we see it here in the Balkans, the former Yugoslavia, with Italy across here. And some of the key commanders who were convicted, all but one of these people were convicted in various ways for the events at Srebrenica, amongst others. Starting really at the top with the big hair on the far side is Radovan Karadzic, and he was the president the Bosnian Serb Republic, a sort of breakaway purported state. Next to him is General Ratko Mladic, who was the commander of the military force. He was also convicted, and they were both convicted of being in what's called a joint criminal enterprise together. Now then we have a group of, they're quite senior commanders who were all tried, and because I worked on all three of those trials, the group one, Karadzic and the Mladic, I'm going to focus a lot of my comments on those. And amongst these, one of the issues that came up that I'm going to talk about is some of these, such as Pandurovic, belonged to what's called the military line, chain of command, and some, such as Popovic, Beara, and Nikolic, were what's called the security branch. And in military terms, the security branch had a separate professional chain of command from the military branch. So during trial, there was a certain amount of cutthroat defense, which you sometimes see in regular domestic trials, where the one side was saying, it wasn't us, it was the security side. Security side, it wasn't us, we had no authority. It's the military command. So that was quite a complex. And as with, it wasn't correct, it was disproved. But as with many lies, there is an element of truth underlying it, in that there were, for some purposes, separate chains of commands, if they had been formally adhering to that. We also see, just by way of interest, a picture of Radovan Karadzic disguised as Dr. Dragan Babic when he was on the run for about 11 years. Despite making, you can see there's a microphone, making public appearances. So it was a sort of open secret. And it suggests that justice can be very slow, but eventually can catch up to even quite high, powerful individuals. I'm going to go through very briefly some of the key trial challenges and then talk about genocide. So the first one, and I'll show you some of the evidence that we used to combat this, was effectively deaths that occurred were military occurrences. People died during war. It's unfortunate. There may have been some bad eggs that committed a few scattered crimes around that, but this was not an organized, large-scale operation. The second I mentioned already was the dual command lines, resubordination, movement around of units, and the third, attribution. So how do you go up the chain of command, for instance, to someone like Karadzic, who physically wasn't there at all? So for a start, we had, for instance, Directive 7, which preceded by some months the actual killings. But you see here, as a broad framework, they did call for operations to create an unbearable situation of total insecurity with no hope of further survival or life for the inhabitants of Srebrenica and Zepa. It's actually quite incriminating. I mean, I said that people don't confess, but this has a certain incriminating tone to it. The defense argued, well, this means combat operations. This means through military activities that we no longer have this enemy in our midst. But we were able to add other layers of evidence. So including this video evidence, you see here, Mladic sending a message to his troops that the moment has finally come to take revenge against this pejorative term for Bosnian Muslims, that sends a certain tone. And he was very much the commander on the ground. When you see the video, everybody physically responds to him and immediately imitates his movements. You then had the video as well, footage of men from age, I think, 15 through to 77 being separated out. And I'll come back to this because it was a course of argument point for the genocide about, well, the women and children were spared. How is it genocide? You're not killing everybody. We then had these aerial photos provided by US intelligence, and you could actually see, in some cases, the buses which were delivering prisoners. This was the first major execution site, Kovica warehouse, for the first major execution. And we actually had video from someone who drove past. This is the same warehouse during, just shortly after the execution. You can see bodies lined up and some of the Bosnian Serb soldiers there. And here it is a few months later in winter. You can see the amount of munitions that were fired at this warehouse. One of the key aspects was the burial and reburial of the bodies. You can see here from before the killings, by July, and the killings occur around about 13, 14, 15, and then a couple of days later, how all this dirt has been removed. And there was a lot of forensic, really interesting aspects to that, but unfortunately I don't have time. In terms, one of the key aspects, it might look like sort of crazy typing, but this is an intercepted conversation that between one of the key accused, whose case I worked on, Bayara, and a key commander, Krstić. And what you see in essentially Bayara is saying we've got this huge problem. If you go over the page, right at the bottom, slightly obscured, they're using this coded terms, 3,500 parcels, which means prisoners that I have to distribute, which means kill, and I need soldiers basically to help kill them. We had evidence showing they did at this time have 3,500 approximately prisoners that the Krstić, the higher commander, sent 30 or so troops to help kill, and they were executed. So those intercepted conversations were absolutely critical. You can see here, this is shots from the Mladic trial, Mladic himself, and one of the unexpected aspects, that's not Mladic that she's pointed to, one of the slightly unexpected aspects was we had this Supjanovic, I think. Anyway, she came and testified that Mladic had an alibi. He was at her wedding. It's hugely detailed. It was actually 2 days after the killing, and he did actually go to the wedding, but he left earlier than he said. Had some very detailed evidence showing that she was essentially expanding the time he was at the wedding so that he couldn't have received this very critical phone call about what was happening in terms of cover-ups. So those, bringing together all those forms of evidence, plus many witnesses, etc., were able to prove these were crimes, these happened. And then a number of legal questions came up in terms of genocide. So I'll say a couple of words. I'm not sure how many minutes I have left, maybe 5 minutes.
Yeah, 5 minutes.
Firstly, this argument was raised, as mentioned. This was not genocide because there was no attempt to kill a major part of the group. In broad numbers, we have about 7,000 murder victims, the men and younger men. Then we have about 40,000 women and children who were forcibly displaced from the area. So there's no doubt that the majority of the victims were not killed. And genocide itself, as applied at the international level, at the international tribunals, requires the intent to destroy the group physically, so not just culturally. The little tidbit, the destruction of cultural sites, religious sites, can be evidence of the intent to destroy the group physically. But if that's all you had, and you didn't have any of the physical destruction, our experience showed in outside of Srebrenica, in other municipalities, that the judges didn't qualify that as genocide. So it's a much harder case to sell if you don't have that bulk of actual killings. So we were able to argue, though, that with enough international attention, albeit imperfect, the Bosnian Serbs understood if they started killing the women and children, who Dutch Bat had been in very close contact with, it would have heightened the chance of immediate response. And so to commit genocide, you don't have to commit the perfect genocide. And that was successful ultimately. There was also a more technical argument about, hey, how is this genocide against the Bosnian Muslims when it's only a small number, small when I say 7,000 men and boys who died of the Bosnian Muslims of Srebrenica and Srebrenica. So this part of a part argument. And we were able to argue that no, that's to do with the specific intent to destroy in whole or in part, and that they did intend to destroy the part, which was the Bosnian Muslims of Eastern Bosnia, because by killing 2 or 3 generations of men and forcibly displacing all the women and young children from this area, they were jeopardizing the continued existence of that group, and that group, because of its significance for Bosnian Muslims more generally, was a substantial part of the group. So these arguments did hold. And then the final point, proving the specific intent. And you see here the definition, genocide really does revolve around that intent to destroy in whole or in part the national, ethnic, racial, or religious group as such. And what I'll say about that, aside from many witnesses that came and testified, there were 2 aspects. One was the physical involvement in a range of killings, organization, some quite prosaic type of activity, like providing fuel. So one of the accused, Popovich, a key thing he did at a key moment was provide 500 liters of petrol when it was needed to move bodies. And that was, even though it sounds quite banal every day, was actually helps them covering up the tracks and carrying out executions. So there's a lot of small activities accumulated, but there was also derogatory language, which was interesting because the judges did not place much weight on it, but they took it into account when they were assessing the specific intent. So they didn't ignore it completely, and they could see where the accused were making these statements at the same time as overseeing, facilitating mass killings, that it could add up to specific intent to destroy the groups, or the group in this case. A final word with the witness, who I think she summed it up quite poignantly when she came to testify in The Hague. She actually testified in Krstić and Ptolemija cases. So she was one of the mothers of Srebrenica, who lost her husband. I think she lost her son. And she saw this statue in The Hague, if you've ever been to the waterfront, of this lady, a sort of fisherman's wife, looking out to sea, waiting for the fishermen to arrive back. And she said when she saw this, it reminded of her and the mothers of Srebrenica, waiting for these men to arrive back, and that never came back. And so she actually asked for a copy, and one of the prosecutors got her a little copy of the statue to take back with her. But her and many others have been sort of left with that legacy. And I think that brings us round to this point about the various proceedings. Of course, putting the emphasis and the accountability on those who perpetrated the crimes, but also looking forward to what lessons can be learned in terms of the UN, its own presence there, the fact that, for instance, airstrikes were called for, they were not implemented immediately. At one point, the excuse given, and I think to me, it sounds like an excuse, that the wrong form was used to request an airstrike at a really critical moment that, who knows, it's counterfactual. It's hard to know what would have happened otherwise. But I think certainly the ability to examine in detail and have a level of accountability for that kind of action is very important. So I'll stop there. Yes.
I wonder if you were actually at the trial when I went to the Modest trial. I don't know. I could have been there. Anyway, I was the very excited audience member. Anyway. Yeah, thank you so much to the panel,